Trump will face the Michael Jordan of RICO, according to Fani Willis's hidden weapon. When Donald Trump and 18 co-defendants attempted to overturn the former president's loss in Georgia's 2020 presidential election, Fulton County District Attorney Fani Willis turned to a legal strategy she had previously used to prosecute violent street gangs and corrupt school teachers. Willis was able to file charges against Trump and his associates thanks to Georgia's racketeer-influenced and corrupt organizations, or RICO, legislation for allegedly engaging in a complex scheme to rig the state's 2020 election. They were charged of directing a criminal enterprise, with the aim of assisting Trump in keeping his position of authority in the unprecedented 41-count indictment. Tanya Chutkan, a district judge, recently made a cruel move that absolutely ruined Trump's mission. Before I begin, kindly hit the subscribe button and enable notifications to receive daily premium material for free. I will go through everything in this video. On Friday, August 18th, attorneys for former President Donald Trump and federal prosecutors met in a federal court to discuss initial restrictions and information sharing regarding charges related to the 2020 election. Trump's future trial, which is scheduled to begin in January, will be decided in large part by the proceedings before U.S. District Judge Tanya Chutkan. In a critical development, Chutkan issued a protective order to control how confidential materials were handled by Trump's legal team. This action aims to ensure that such materials are not disclosed to unauthorized parties, protecting possible witnesses from intimidation and preserving the fairness of the trial. The protective order came after special counsel Jack Smith's office expressed worries about Trump's public comments that would adversely damage witness reliability in the broader trial setting. The contrast between Trump's First Amendment rights and the need to prevent undue influence on the proceedings was highlighted by NBC News in its extensive report on Chuck and his comments. Like every other American, Mr. Trump is entitled to free speech under the First Amendment, Chutkan said immovably. But it's worth mentioning that this right is quite restricted. The allegations against Trump are focused on alleged attempts to skew the outcomes of the 2020 election, including collusion to defraud the U.S., obstruction of justice, and conspiracy to suppress the right to vote. Trump's legal team has contended that while he might have violated the Constitution, he didn't commit any crimes. The case involving a former president and a candidate for the next election, both from opposing parties, is exceptional, according to John Lauro, Trump's attorney. He said that the requested protective order might interfere with Trump's freedom of speech. Chuck can, however, reject the notion and state that politics ought to be kept out of the courtroom. The need for a protective order to protect witnesses and stop the manipulation of discovery documents was emphasized by prosecutor Thomas Windham. Chutkan accepted the suggestion and agreed to include witness interview transcripts in the protective order's list of sensitive materials. Trump's legal team and the prosecution argued over potential trial dates as the trial drew near. Smith's legal team suggested starting the trial in January, noting the general public's desire for a speedy decision given the importance of the case. However, Trump's response is still awaited. Chuck can conclude the hearing by pleading with both parties to refrain from saying anything that might affect the course of the trial, stressing that any ambiguities might cause the trial to proceed more quickly. In the comments area, you can voice your ideas. I appreciate you staying until the very end. Willis hired John F.L.